groups before they choose to do that. But because the consequences are so harsh when that happens, you're going to be personally liable at that point. It's very important to take steps to try and avoid that happening. Okay. Some of the factors that courts look at: failure to follow corporate formalities. Have you've filed your articles of incorporation, so your corporation is created, but have you issued stock certificates? Are you holding your annual shareholders meeting like you're supposed to? Are you doing those things that respect that entity as being separate and apart? Intermingling of affairs, failing to separate your business affairs personally from the affairs of the corporation. Inadequate capitalization, how much money has been put into the corporation, how much insurance coverage does the corporation have to protect against certain types of claims, and fraud cases. If the case involves fraud by the corporation, then courts are going to be more likely to pierce the corporate veil in that context.
Mr. Smith, is going after the Madoff assets and things like they were going to auction off his yacht and things, is that an example of this?
I believe it is. I mean, obviously, you want, if you're going after, if you've got a claim and you're trying to recover amounts, you want to go where the money's at, okay? And so a lot of times, these corporate entities may not have sufficient assets on the corporate level to pay off what you think you're rightly entitled to, okay? And so where do you go next? You go to the individual shareholders, which can be, if it's a large corporation, these can be wealthy individuals with, with personal assets that you want to get to, okay? And obviously, from the shareholder perspective, that's never a good thing. People incorporate primarily for the purpose of preventing that from happening, okay? And so you don't want it to happen. So what can you do? What can you do to prevent that from happening?
Well, I got a question before you get there.
Sure.
You mentioned piercing the corporate veil and going after the shareholders. What about the stupid board of directors that approved the business practices that caused the corporation to go bankrupt?
Well, directors, while they may make bad decisions sometimes, they're generally protected by what's known as the business judgment rule, okay? And what the business
Well, it's obvious the company went bankrupt, so they do not have any judgment.
Well, it's usually a little more complicated than that. What the laws don't want to do are place restrictions on directors that make them afraid to take certain actions that might benefit the corporation. They don't want to make them too conservative where they're afraid to do any business deals. And so that business judgment rule is a presumption that directors have acted in the best interest of the corporation. Now, I see you grinning there. There are ways to rebut that. It's just a presumption. Okay, it can be rebutted like any other presumption, and directors, at times, sure. I mean, it's a balancing approach of placing restriction on directors where they are too afraid to take action versus giving them too much leeway to go out and do whatever they want to. Okay. Well, I do want to say, with intermingling corporate affairs, just for a second, we face this a lot of times, and it's really hard to do in small companies. You don't want a bank account where you pay your mortgage out of day one, and then from the same bank account you pay your office lease space the next day. Don't take a $250,000 no interest loan from your corporation. Don't pull out $10,000 from your corporate account to go buy a jet ski. Courts are certainly not going to look favorably on those actions. Okay. So that's it. I hope you have a better understanding of what the advantages and the disadvantages of incorporation are and kind of the steps required to get to that point. I think we're a little bit short on time, but if anybody has questions, I'll be around for a little while afterwards, and we'll be more than happy to talk to you.
Thank you so much.
Thank you.
Hello, I'm Jennifer Brinkley, and like our presenters this evening, I'm also a corporate attorney. I've also invested in corporations. In fact, in the year 2000, I made an investment in a tremendous commodity when I married my husband, Charles Brinkley, who will be speaking to you tonight about corporate litigation. Charles is a native of Huntsville. He's also a graduate of Athens State University. In 1993, he graduated with a business degree and went on to graduate from Cumberland Law School at Samford University in 1996. Since then, he's been practicing with the law firm of Brinkley and Chestnut, where he specializes in the areas of corporate litigation, bad faith and fraud, personal injury, products liability, car and truck accidents, and other related areas of law. I can personally vouch for the fact that Charles is very involved in his community. Besides Wednesday night basketball at Brinkley and Chestnut, he is also a board member on the Partnership for a Drug-Free Community Board, and for many years he has been the president of the board of the Child Care Center at First United Methodist Church. Charles has two very loyal fans. They're very small. Their names are Charlotte Elizabeth, who's 2, and Eleanor Francis, who's 6. They are our daughters. Please welcome Charles.
Thank you very much, Jennifer. I couldn't have done a better job myself. One thing she did forget, and this is extremely important, is I have recently, I'm recently an assistant coach on the Blue Angels T-ball team. So I think that, and that's hard work, let me tell you. I didn't realize it, and they had a game tonight, but it was canceled. But my most brilliant achievement was to persuade my wife to marry me. Winston Churchill said that. What he also said, and this is a quote that's more related to the topic that I'm going to talk about tonight, you have enemies? Good. That means you stood up for something in life. And that's what I think we feel like a lot of times when, as a plaintiff, we're litigating against corporations. We've got this corporation, attorneys like Chris, who was just here, and 5 other attorneys that are with them, and then you've got me and my plaintiff. And so we have to stand up for the rights. And let me just tell you this, I do represent corporations too. I do defend corporations. I defend corporations. I have corporations that they're the plaintiff, and we do sue other corporations. I sue on behalf of individuals against corporations. So you can see there's a lot of things that take place when you're dealing with corporate litigation, and that's really what I'm going to talk to you about tonight. But corporate litigation takes up about 60 to 70% of what you see in the courtroom. And so my first part of the speech, I'm going to talk to you about just the practical considerations of taking a case, trying a case, just a few topics relating to that. And then I've done a lot of research on the case law itself. As Chris said earlier, there is thousands of cases on corporations. And so I picked out, I believe in your outline, you'll see 49 of those. I couldn't get to 50, 49, I stopped at that. But I have 49 cases. And I'll touch on a few of those, but I'm not going to hit all of those. One axiom that has been that Alan actually told me, and Joe Barry told him, and obviously nobody's following it, do not give a lecture on trial tactics in your hometown. Well, I'm going to do a little bit of that, but I'm not going to tell you all of our secrets, and we may not have any secrets, but I'm not going to tell you all of them. The first question is, do you sue? I have people come in and talk to me, corporations, people that represent corporations, plaintiffs, about all different types of things. And they come in and they're excited about their case. They want to tell me all the facts about it, and I'm excited about hearing it. But we don't sue on principle. And a lot of times people go, it's just not right, and I want to sue on principle. And that's great. I wish we could do that. But unfortunately, what our court system does is the standard for the jury is money. So the way they punish people, it's not Hammurabi's code. We're not going to cut off their arms, cut off their tongues, eye for an eye. We're not going to do that. We're going to make a judgment, the jury is, based on money. We're either going to give you this much money or we're going to give you 0 or something in between. And that's what the jury's going to decide. So we don't sue on principle. So they come in, they'll tell me their story. Well, what I want to look at with that corporation we're going to possibly sue is there insurance to cover this? Do they have money? Do they have assets? Are they insolvent? A lot of times they're going to have insurance coverage. These companies are going to, for different types of personal injury. But like I said, I do represent corporations for debt. And it's not fun to go ahead and try to collect debt from a corporation that has tax liens, that's insolvent, and you can't collect anything. In fact, a lot of times they won't answer anything because they're going to bankrupt and they're insolvent. So that is that's something that you really need to look at, and I think it's important, and sometimes people miss that. Another thing that we look at is who do you sue and who do you serve? Well, we talked about all the different business corporate forms Chris talked about. We look at different types of forms: corporations, LLCs, LLPs, PCs, partnerships, all these different corporate forms. So when somebody comes in, a lot of times they don't know exactly what kind of business form it is. You can find out. We can talk to the Secretary of State, see if it's a corporation. We can find out those things, but you need to find out who you sue. Also, a lot of times you'll have a situation where somebody comes in, let's say it's a truck driver, and your client comes in and says they've been injured. A Coca-Cola truck or some sort of truck injured them in a wreck. And they go, and this truck driver, and he did this, and he did that, and he injured us, and and another thing is you don't want to necessarily sue that person. He's an employee of that corporation. And so there are situations where you do serve the individual, but you want to sue the corporation he works for. You don't want to create any personal sympathy as a plaintiff for that individual, and you don't want inconsistent verdicts. You don't want to sue the individual and the corporation and have inconsistent verdicts. So what you do is you find out if it's a corporation, LLC, and then you sue the corporation, LLC, whatever type of business form it is. The doctrine that you sue them under, that you get the corporation under, is respondeat superior. And I won't go into this that much because I could probably do an hour on this topic, but a prima facie case for respondeat superior is that your client sustained some sort of injury, and that injury is due to the negligence of that employee. That person whose negligence caused the plaintiff's injury or property damage had the corporation as it was an employee of the corporation, and the defendant was acting within the scope of the employment. And the scope of employment, the definition of that's, again, there's many cases on what that is. But that's a prima facie case, and the scope of the employment, why, while an employee of the corporation. Okay, so again, number 4, another question that you get. People come in, they tell you your case, and they go, what are my chances of winning? And they're fired up, and they want to know, and they want you to be fired up and excited about their case, and I am excited about it. I do get excited about what their case is. But when they ask me that question, I have to tell them that I'm not Nostradamus. I can't predict how their case is going to turn out. Their case is always 50-50. You go down 2 years down the road, you've heard that half of the story that they've told you, and you get down the road, and the defense has whittled it down and taken shots at you, and you've just got this one little issue now. So your case is always 50-50 when you show up. Another important part when you're in trial is what you can say about the corporation. And what I'd like to do for you is read an excerpt from a trial, a closing argument. This argument was, or this case is Chrysler versus Hassel. Chrysler versus Hassel.